Good evening, everyone, and welcome to tonight's town hall meeting. The subject of tonight's meeting is our changing legal profession. Is it a crisis or is it an opportunity? Tonight, Dean Kellye Testy and Executive Director Paula Littlewood are going to be answering questions, discussing the challenges and the opportunities to the legal profession, and answering questions that you might have with regard to how the changes in the legal profession are going to impinge upon the public in general and upon law school students and the general public. First, let me read off here some housekeeping details. For our online attendees, your login is your sign-in, and use either your username or the guest login that you've been provided. As a courtesy to others here in the room, please turn off your cell phones or put them on mute. The restrooms are located right over here. You notice there is a code needed to get in, 5182. There are some refreshments in the form of coffee, tea, and water that are available. Please help yourself. Since this seminar is going to be videotaped, and since it's online, we're going to have to ask you to use a microphone when you're asking your questions. So once we get started with the questions, just raise your hand and I will point to you and we will deliver you a microphone so you can answer questions. The recorded broadcast of this town hall is going to be available on the websites for both the Washington State Bar Association and the University of Washington Law School sometime next week. Before I get into introductions, I'd like to recognize some people who are here in the room. First of all, I'd like to recognize Superior Court Judge Jerry Johnson. I know he told me he's ex-judge, but we'll still call you Judge Johnson. We have Mr. Bill Gates Sr. here in the room with us this evening. And we also have Mr. Ken Masters, who is a member of the Washington State Bar Association Board of Governors. Now I'd like to introduce our speakers for tonight's town hall meeting. First of all, Paula Littlewood. She is the Washington State Bar Association Executive Director, and she joined the Washington State Bar Association staff as Deputy Director in 2003 and became Executive Director in 2007. She is a graduate of the University of Washington School of Law, and she also received her master's degree in international studies from the University of Washington. Prior to law school, Paula was a professional campaign coordinator and fundraiser here in the state of Washington, working both on statewide candidate and initiative campaigns, as well as for candidates in local races. Paula also taught English in Taiwan for 2 years, and after that had another 10 months traveling in China and Southeast Asia. After law school, she served as assistant dean for administration and public relations at the U for a period of 5 years. And Paula is also now a member of the task force on the future of the legal education for the American Bar Association. Dean Kellye Testy is the first woman to join the distinguished group of permanent law school deans. Dean Testy is a prolific scholar. She's an outstanding teacher and is an experienced dean. She is focusing her scholarship right now on corporate law and governance and leadership. She serves also on the executive committee of the American Association of Law Schools and is a board member of numerous legal and civic organizations. So for the next next 90 minutes, Dean Testy and Paula Littlewood, sorry to cut you off, are going to discuss their thoughts and answer your questions on the changes in the legal profession and the effect of those changes on the legal profession. I'll be fielding the questions for those of you in the room, and we'll also have, someone in the back who's going to be taking the questions from those people who are online, and there are about 70 to 75 people who are online tonight. So it's now I'd like to ask each of Dean Testy and Executive Director Littlewood to give some initial introduction.
Thank you. Would you like to go first, Richard? Well, I'll preface all my comments by saying that I think this is a time of huge opportunity for our profession, and I think it's a really exciting time. There's definitely a lot going on. I would say that there is a tidal wave of change coming to the profession. But if you had a chance to read your most recent issue of Northwest Lawyer, I talked about some of the trends that are at play in the profession, impacting the profession right now. And what I pose to the profession is we see this tidal wave coming, and I think we have two options. One is to paddle out and ride the wave and seize the moment, or we can wait until that wave crashes down over us and we'll be standing on the beach trying to pick up the debris. So I'm going to talk really quickly about the 5 trends. There's lots of trends, but I'm going to just highlight 5 tonight that I went into more detail in my column, but I'll just sort of go over them at a high level that'll hopefully help sort of engender our discussion tonight. So the first is the changing demographic of lawyers. The one thing we know is that in the next 10 to 15 years, huge amounts of lawyers are going to be transitioning out of the profession as they begin to retire. And we have a bar chart, the bar graph that we use at the bar. We've been watching this trend for probably the last 5 or 6 years and preparing for it. And there's these big bars kind of on the right side of the graph. And then there's this little bar coming in, and this is the new lawyers coming in. And they're sort of hitting this big wall of all of the baby boomers and the traditionals who haven't quite transitioned out of the profession yet. But they are going to start transitioning out in the next 10 to 15 years. And so I think one question we need to be thinking about is when that wall falls away, if this little bar chart over here, or this graph over here doesn't get bigger, we're going to be looking, I worry, about a shortage of lawyers. The other question is, how do we capture all of that experience and leadership that will be transitioning out, and how do we create opportunities for these new lawyers to really come in and take over the profession? So that's a big trend that we're certainly watching at the State Bar. The second is just the changing nature of our world. And I'm only going to highlight 2 things about that. If you look at my column, I talk a little bit more. But I think 2 of the most important trends that we as a profession have to be watching is the haves and the have-nots are getting further apart. And that has only been exacerbated by the recession. And so we're all familiar with the famous 1% that came out of the 2010 census. And we have to serve all of the public. And so as this have and have not population gets further apart, how are we going to serve all of those people who need our services? The other big trend, of course, is technology and how it's changing how the world runs, but how we do our work. And lawyers have traditionally been late adopters of technology, and we need to get on the boat and start using technology, I think, in different ways. And we can look at other professions and see how technology impacted it. Look at how you get your newspaper now. Look at how you get your music now. Look at how you read a book now. So we can't stand around and say technology is not going to have an impact on our profession. It's already impacting our profession. The third trend is just the changing business model of how we do our work. We all watch the big law firms, some are getting bigger, some are imploding. One thing we know, again, I think exacerbated by the recession, is that more and more folks are going out on their own, particularly the newer lawyers that are coming out. They're not finding the traditional jobs either in the state sector or with the large law firms, and so they're going out and they're hanging a shingle because they don't have any choice. And they've got these staggering debts, which, of course, I'm sure we'll talk about tonight. And so that's a big change. The other change that's coming, and I know we've all heard this for decades, but I think it's really going to happen, is the call to the end of the billable hour. And that's the billable hour is often cited as the number one dissatisfaction for lawyers with the profession, but also dissatisfaction by our clients with the profession. But what's really driving this change that you're going to, I think, see a move towards value-based billing is that the corporate clients are driving us, and they're going to their outside counsel and saying, we're done. We can't go to the CFO and the CEO anymore and say, we've exceeded our legal budget. And so now many of the corporations are working with their outside counsel to do what we call value-based billing. What's interesting is that if you talk to some of the larger firms, particularly in Chicago and New York, they look at it and they say, actually, this is a great deal, this value-based billing, because they can take a senior team or a team that goes to meet with the client that can have senior lawyers and associates, right? Because as we know, a lot of the corporate clients and other clients are saying, I'm not going to pay for your associates to come anymore. I'm not paying to train your associates. So this value-based billing, I think a lot of the law firms are finding it to be really great. So we are seeing, I think, a trend towards, or maybe I should say away from the billable hour. It won't go away overnight. That's not my comment, but I think it's a trend we need to watch. The fourth trend I would highlight is the changing nature of our clients. And clients are sort of taking on a Home Depot mentality, right? I can do it myself. I can go out to LegalZoom.com and I can figure all these things out. Most people either can't afford a lawyer, or if they can afford a lawyer, they want to do it as cheaply as they can. I think the medical profession saw this probably 10 or 15 years ago, right? When patients would walk in and they'd done all the research online and they're like, here's what's wrong with me. And the doctor's like, well, that may not be it exactly. But we are definitely seeing clients a lot of times because they can't afford a lawyer, but because a lot of the work is becoming commoditized, they can actually go out and do these things online. The last trend I would highlight is the delivery of legal education, and I won't talk too much about that because I know that'll be a topic in general, but I think two things to highlight with that is that applications for law school are down nationwide, about 16%. And so, and I know not necessarily here in our state, but certainly nationwide, I think people are looking at the law and looking at legal education and saying, big debt load, median salary for lawyers is $62,000. This may not pencil out. So I think we need to be watching that there is a big decline in people coming to our profession. And then I think the debt loads are huge, not just because of the debt loads, but we're changing the face of the profession. And what I worry about is that who we're squeezing out is the middle class, right? So those that can afford to go will be able to go, and those who are sort of in that lower income will get the aid they need, but it's the middle class that's starting to get squeezed out, and I am very concerned we're changing the face of the profession. So I will stop there and pass it over to my good friend.
Thank you very
Paula.
much, Dean Testy.
Thank you so much. Let me start by saying that most of all that Paula shared, I share your views about. I think that there's not a lot of points of departure that I have with the description that I think Paula gave us about some of the key trends. And so let me just mention a few things just in a little bit deeper way. Let me start with saying that I guess I may go more for the crisis, but I don't think a crisis is a bad thing. In fact, I've often said, never waste a crisis, right? It's sometimes the way that innovation starts and the way that you can finally get some change. And so I also think that we shouldn't confuse change with a crisis, and that I know people fear change, but I actually am really happy about some of the questions that are being asked about legal education right now, really happy about some of the questions being asked about the legal profession more generally. And partly that is because of my statement that I think there is a bit of a crisis, and I would describe it as this. Paula noted that the gaps between the haves and have-nots in our society are ever widening. And so we have a very odd time happening here in that the gap in access to justice in our world has never been greater. There's a tremendous inability right now of the general population to receive the kind of legal counsel and legal resources that is needed. And so the gap in the people that need legal resources and those that have them is just ever widening. At the same time, we have a very strong argument that there's an oversupply of lawyers. And that's an odd market position, right? To have both an oversupply of something, of the lawyers, but an undersupply of lawyering and justice in society. And so I think that really does present us a stark question, because if what we allow to happen through that is that people quit going to law school, quit choosing law as a profession, and Paul is right about the demographics, you're going to have that problem worsened because you're going to have too few people that are out there to address society's needs for legal services. And so I think that's something I hope we can talk a little bit more about. The other point that I want to pick up on that she made is that if you think about the points Paula made, there are several change agents that she mentioned that are affecting the legal profession. Technology, global and competition that comes from that, complexity. Every major problems now are ever more complex, and the intersection of things like medicine and technology and law and the sciences, et cetera. And the business model, right? The way that the clients are thinking about what they expect. Now, the legal profession can't be immune from these things. Every other part of society, every other business has also had to respond to changes in technology, changes due to globalization, changes due to clients' demands for doing more with less. And so I think that we're facing this, that it's time for us to figure that out, is a bit overdue. There's been a lot of innovation happening in law schools. Some of that's more known than other parts of it. But I do think it's no surprise that we are facing those kinds of questions because everything else in our world is facing questions that are spurred by exactly those factors. The other point that I want to make as an introductory matter here too is that there's been a great deal of discussion about changes in the legal profession and about concerns that about underemployment of lawyers. And one of the things that I would ask us to talk a little bit about tonight too is that is very different depending upon where you are looking. In this sense, many law jobs now are not necessarily in law firms. And so a lot of things that you hear about are measuring just simply employment in law firms. Our graduates, as an example, UW Law School is a very interdisciplinary law school. A lot of our graduates become people in business, they become people in health, technology, etc. And many of those are law jobs. It's just that they're not in law firms. And so some of what we have to realize when we're talking about the crisis is that the way legal services are being delivered has changed. And lawyers are much more embedded now in other organizations and entities than in standalone law firms. And then finally, the other point that's related to how legal services are delivered that I think we need to consider is that as law becomes more complex, it may be that we need to think more creatively about who it is that's delivering the various kinds of legal services. And I know Washington's been at the forefront of thinking about a limited license practitioner that can perform some legal services, not everything that a JD credentialed person can perform, and therefore try and close some of that gap between the public's need for legal counsel and what we're able to provide right now in the model that we have. So let me stop there because I know we don't want to talk at you too long. We want to hear what your questions are and the areas that you'd like to discuss.
Thank you very much. Let's start with a question here in the audience.
Yes.
There's a microphone on its way. Thank you.
I'm really concerned because I go to schools like Franklin and I talk to Black youth. I'm not sure that with a clear mind I can encourage them to be lawyers. There is somebody present who, when the King County Bar Association gave funds to the University of Washington for the minority program, said that this, through the law, was one way of bridging the gap so that people can earn good money. However, I don't know that that is true anymore because neither of you talk about the overwhelming debt that is placed on new lawyers for their college and law school education. I have a young man who was a legal assistant to me, and he was terrific. He was so good, I said, "You're kidding me. You've been to law school and you're just denying it." That's how good he was at research and so forth. And I've encouraged Richard to go on to law school. I'm not sure that's any more good advice.
Right. Well,
The bill is too high.
it is. Well, I think I did talk about it in my introductory remarks because, as Kellye will attest to, I've been nipping at the dean's heels here in the state for 4 or 5 years. I think it's a huge problem, and that was my comment that it's changing the face of the profession. We're squeezing people out. I sat down and had coffee with somebody yesterday who did very well on the LSAT and, has the desire, and they look at the dollar and cents and they say this doesn't make sense. So I think it's a big issue. It's a complex issue. We know that. But I think it's going to take university administration getting involved because I think that the law schools, we know, and I will exempt the schools here because I don't think it's true, but we know across the nation that law schools are seen as cash cows. And that in some universities, fully, 30% of the money they bring in is thrown over to the rest of the university. It's a huge problem. And as Al mentioned, the ABA has a task force looking at the future of legal education. I have the honor of being on that, which I think provides Washington State a huge opportunity to impact this issue. It has to change. The whole model has to change. I don't think the dean will disagree.
No, I wouldn't in this sense, Lim. And let me say that there are a lot of longitudinal studies about whether people who have selected law as a career at different points throughout their career, they're asked, are you still happy you did this? Was it worth it financially for you to do it? What's interesting about those, all the data shows people answering yes at every point. Now, that, by large margins. And that's been true for years. It's still true in the most recent studies that have been done. So part of what we need to also temper our discussion with is the question of, if not law, then what? Sociology? Anthropology? My point is simply that there's a lot of economic dislocation in our world right now. And so to say, not this, you also have to ask the question of then what else for a student? So one of the things that I think that about that is that if you chart a line of the University of Washington Law School's tuition increases, it matches exactly the state's disinvestment in higher education. And so, the public schools in this country have been the schools that have been out there as the beacons for access to say, whether it's undergrad or whether it's law school, you don't have to be a person of means and you don't have to win a fancy scholarship to go. But as states have just continued to withdraw support for higher education, that's not only hurt undergraduates, it's also hurt law students. And, it's one of the things that I think we really need to think about. Most of the public law schools in this country still have incredible tuition. There are a few of them who have kind of privatized. Right now, as an example, our in-state tuition at UW Law School is about $30,000. If I look at our peers' tuition, you look at a Berkeley, a Michigan, a Cornell, a Columbia, it's at least 50. So we're 20K under those tuitions. Now, when you hear that number, though, $30,000, that's a lot of money. You times that times 3, right? Most of us went to law school to avoid math, but we can do that one. You see that it's still a hefty price. Now, one other quick point about this is that in most other studies that one can look at about tuition levels, a high tuition, high financial aid model is shown to create the greatest access. And so one of the things that we also have to keep in mind as we talk about this, it's not the sticker price, it's the cost of attendance that matters for a student. And so if you're able to have funding for scholarships, that means that you can assure more access than one might think by looking just at the overall, sticker price, so to speak.
I would just add one other thing because I think part of what your question gets at is the pipeline of folks coming into the profession, particularly from traditionally underrepresented populations. One of the big concerns we have at the State Bar is we're not retaining people. And so, my comment is if you have this great pipeline of, elementary students and high school students and college students all excited about going to law school and becoming a lawyer, and then they leave the profession, we've in essence created a pipeline that's emptying into a sieve. And so last year we commissioned a huge membership study Because what we were trying to figure out, probably one of the more important questions we asked wasn't why did you leave the profession, but why did you stay and what worked, so that we can develop programming to help our members and help employers understand what are the factors that help people stay once they get into the profession. Because if you go through this whole gauntlet and you do take on this debt and then you get into the profession and it doesn't work, you're not in this sort of supportive environment to help you thrive, then we're failing too. So that's a huge issue that we're taking on. Retention is a big issue for us at the State Bar, particularly for traditionally underrepresented backgrounds, folks with traditionally underrepresented backgrounds.
Are there any follow-up questions on the cost of legal education? Right here in the front.
Thanks. Connected to the issue of access to law school, it always occurred to me, I graduated from the UW in 2002, and at that point, I was the last class who got in under the cheap tuition. It's made things a lot more available for me, but we had discussed at the time loan repayment, and I don't know if that's available now. It wasn't back then, but it seems like to me that that's the true meshing point between access to law school and provision of legal services to the underprivileged. Because you can go to law school and come out with $1 zillion in debt, and you can't do that work. I also don't think it's necessarily a great thing to have people get a free ride scholarship and end up making $1 million at the big law firm. So that's not helping the people who need the legal services. So does UW now have an LRAP?
Yes, we do. And your question's a great one because an LRAP or a loan repayment assistance program is, I think, the most perfect form of financial aid for exactly the reason you describe. So you're not giving a scholarship to someone who then is actually making a whole lot of money, and you're matching it up with giving people an ability to choose a job not based on how much it pays, but by their passion and what they want to do and contribute. So the answer to that is we do, and many law schools do today have LRAP programs. And the federal government has moved into that model for students who choose public interest or public service careers. So there's actually a lot of resources available now for the student who wants to do public interest or public service to be able to choose those jobs and have their loans repaid or forgiven after a certain amount of time in which they in which they serve. There are also a number of wonderful private programs that substantially do the same thing, and I can't help but mention the Gates Scholars Program at the University of Washington, where we have 5 students a year that are able to work in public interest and have scholarships to do that. But let me say that what worries me about that is that gets at people who do the jobs that qualify as public interest or public service. And that's great, and I'm all for it. But it doesn't help the student who's doing more the kind of work where moderate means, as an example, where, so your average citizen just needs a lawyer to do family law or some kind of housing or consumer or wills or whatever it might be. And those lawyers may be earning similar amounts of money to the public interest or public service lawyer, but they wouldn't be eligible for something like that. And so that's the group that then I worry about the ability to make that choice, or even if it's not a choice, to be able to do it if you may prefer something else. Last point is that I have far more students who want to go into public interest and public service than there are jobs. And that comes back to funding issues. Again, the federal government, many states have cut back severely on the number of positions for legal services lawyers or other kinds of aid for the underprivileged. And so therefore, that means that students who really want to do it and probably could afford to do it can't do it because there's no position. We've tried to innovate and tried to help them launch sort of, their own public interest organization, if you will, to help with that. But that's a harder path.
Why don't we let's take an online question now, Rex.
Thank you. We've got 3 questions in the queue. So why should someone go to law school when our own leadership is sending the message that someone with as little as 2 years of post-high school education can be a LLLT and replace a lawyer?
So the triple LT, as we affectionately call it, which is the limited license legal technician rule, I'll just back up in case folks haven't heard about it, is a rule that was recently passed by the Washington Supreme Court, which creates a limited license to practice law in defined areas, and that area hasn't been defined yet. They've looked at family law, they've looked at landlord-tenant, they've looked at immigration, and they've looked at elder law. And actually that board's first meeting is tomorrow, the Triple LT board. These practitioners will not be able to negotiate on behalf of a client or go into court on behalf of clients. So what I generally do when I talk about the future of the profession, and in particular about the limited license legal technician rule, is I ask people, usually they're at a CLE, if you have a pen, to draw a box and make that box into 4 squares. And at the top 2 boxes, write advice and counsel, and at the bottom, write process and content. And this is an oversimplification of what we do as lawyers. But if you look at those top 2 boxes, advice and counsel, that's what I feel like I went to law school for. That was what my 3 years of training gave me that was unique and taught me, as we all know, to think like a lawyer. Those bottom 2 boxes, which are the process and content, is a lot of what you're seeing that's being commoditized. That's a lot of what's getting shipped overseas when you hear about the legal process outsourcing to India. If you look at a lot of what LegalZoom and those folks are doing, a lot of it is that process and content. My comment, the bar and many in the state were very opposed to the idea of the limited license legal technician. You may know we already have a limited license here in Washington, which is a limited practice officers. They are allowed to do real estate closings, so licensed in a very narrow area. We've had that for probably 30 years. It is now a rule, and it is now a program, and the state bar is charged with making that the best program we can make it. One of the things, and I'll give you a sort of a preview of my column that's coming in February, which is the follow-on to the column that was in January about the future, is that lawyers, we've got to let go. And there's a lot more control and a lot more power in letting go, and Kellye's already alluded to that tonight. We're not serving everybody in the public. We just aren't serving the public. And even if we had 90,000 lawyers in Washington state and we have 36,000, we wouldn't serve everybody. And what's happening in other parts of the world is that the consuming public is getting fed up. They're saying, I can't afford a lawyer and I can't access the system. And so what's happening in places like England and Scotland and Wales and Australia, and they're battling it right now in Ireland, is the government stepping in because they're responding to the public, they're responding to the constituents, and they're getting more involved in the regulation and sort of the delivery of legal services. So my comment that I started with about we can see the wave coming, and we can either choose to do something about it and ride the wave and actually have some control over where these things go, really ties into that we can watch what's going on in other places. And if we want to maintain our monopoly, we need to let go and think about how to make something like the Triple LT an excellent program and give these folks the tools that they need. The medical profession did this. They have nurse practitioners. There's only one other program that we're aware of in the world that's similar to this, which is up in Ontario, Canada, and they've been licensing paralegals for 5 years, and they've just come to the end of it and done a big report, and they're finding that it's actually working really well. The way I look at it is the Supreme Court has charged us with making this program the best we can. So to me, it's how do we get all the best minds at the table and all of us embracing this and figuring out how to make it the best we can make it. We're getting a lot of national attention about this. We're getting chief justices in other states telling their people, their lawyers, look at what Washington's doing. We need to be on the forefront with them. We're in conversations, Kellye and I have been having conversations for several months, because I think one of the most critical things about the Triple LTs is how are we training them? How do we train them to know when they've gone too far and a lawyer needs to come in? it's here. And I think one thing lawyers do great is we problem solve and we get excited about that. And this is a great, exciting opportunity to really lead the nation and solve the access, the gap. So,
Thank you.
Do we have any questions here? Here, I'll just give him my.
I went to Catholic University of America Law School in Washington, D.C., and in that area, I was a former patent examiner. And basically, I came in real near the bottom of my class because I was falling asleep. But I mean, I spent all my time working really hard at the patent office and taking the train over and back. And my question is almost like, integrating law in almost a co-op program, almost like the patent office, because the USPTO usually sends 5 or so examiners each year, and they pay for a substantial portion to each of the area law schools or so.
Yeah, it's a really great question, and I appreciate it in at least 2 senses. One is that I think that over the last really 20 years, and especially 10 and maybe even more intensely 5, law schools have done a tremendous amount of innovation in terms of blending skills education into the curriculum. And it's something that, we all know is really important because that's more of what you do when you're out, right? It's also important because I believe that someone learns often better by doing than just by sitting and receiving and talking. Sometimes it's not until we try and apply something or teach it to someone else that we really get it, right? And so today, in most law schools, there's skills education incorporated into a lot of the courses that you would think of as, the basics. As an example, in business entities, there's often now a lot more in negotiations or drafting of agreements than there used to be. Most law schools have really well-developed clinics where students can actually represent clients under the supervision of clinical faculty who are lawyers. And then students do externships where they're doing exactly what you're describing, which is they're spending a quarter or a semester actually on site, and their teacher is not a professor, it's the supervisor at the location. So really what I see today is that, most students have a lot of skills education incorporated in the first 2 years. And for many students, that third year is largely an experiential one, where they're doing externships or clinics or some kind of combination. And so that's something that I think has been a good development. And the next generation of question about it, I think, is how we can more fully integrate all those various skills components with one another, because as many things happen, things grow organically within an organization. So first you have a legal writing program, then you have a trial advocacy, and then you have a clinic, and then you have an externship program. And what we're trying to do now is step back and say, how can all of these fit better together so the student can sequence their learning in a way that makes it even a better progression? And further, how can we make sure that that's in really close dialogue with what we would call the doctrinal courses, as if there's, I put it in quotes because obviously there's a lot of skills and a lot of doctrine in all of this, right? But I do think that's important, and it's something that, we're certainly hearing a lot from law firms and other legal employers about, that they need practice-ready lawyers, that the competitive world that they're in means they can't invest in training like they used to. And furthermore, that the kind of skills that lawyers need today are not just what we think of as the classic legal skills. So as an example, we're trying to do a lot more skills education in things like leadership, in communication, in project management, in quantitative skills, in business and financial literacy, so that our students can have that whole package of skills that can help them enter the world not so much as a newbie, but more ready to, hit the ground running, as we say.
Okay, Rex, can we take another question from online, please?
Ask. Okay. So I'm alarmed by the rise in numbers of companies owned and or managed by non-attorneys, offering so-called quasi-legal services. Please discuss the impact of competition with attorneys and the erosion of quality legal representation for the public. What role can or should the bar be playing in ensuring A, the public is aware of the pitfalls of relying on these mills for legal representation, and B, encouraging formal oversight or regulation of these entities to ensure accountability?
I think you're first.
Well, I think if I understand the question correctly, is the unauthorized practice of law, of course. And, you can drive down I-5 and see the big billboards for these, divorce mills and things like that. So I will go back just quickly to the triple LT rule. That is actually part of the impetus behind that rule, is to hopefully, clamp down on this unauthorized practice of law, and that these folks will sort of come under the tent and get licensed. Now, we've all been a little cynical about that, and I will say I have been cynical about that, in the sense that if these folks are out, doing this and making lots of money, why would they have incentive to go, through the education and the licensing requirements? But what's interesting is when I was talking to my counterpart from Ontario, and as I said, they've just come through this 5 years, what they found, and they went into it with the same, I would say, cynicism, that these folks aren't going to want to come under the tent. They actually found the opposite. What they found is these folks want to be able to brandish that credential, that I'm a, ex-licensed whatever. So that is one of the goals. If you read the rule that was sort of the Supreme Court rule that was the impetus behind the Practice of Law Board looking at creating this triple LT, that was part of it, was to get at the unauthorized practice of law. The Supreme Court has the Practice of Law Board, which is charged with investigating unauthorized practice of law claims. We, as the State Bar, staff and administer that board. We've been having a lot of conversations with the Practice of Law Board. The difficult thing with unauthorized practice of law is that we can go out, we can investigate it, we can have a great case, but we can't prosecute it. And so we have to throw it over the fence either to the county prosecutor or the attorney general. And not surprisingly, and no criticism, they've got a whole lot of things that they're trying to do with not a lot of funding. So that these UPL cases sort of fall to the bottom of their docket is not, I don't think, a surprise. There's been a couple really egregious cases that have been prosecuted. So we've been in conversations with the Practice of Law Board of like, so where do we go? And so my short answer, this was a long answer, but now I'll give you the short answer to the question, is consumer education. How do we, educate the consumers better about the pitfalls, as the question said, and what are their options? What are the other options? And how can they get affordable legal help? So this is a big issue that we're very focused on.
Paula, if I could mention one point about that question too, is that I think there's two different kinds of firms that the question could have been.
Yeah, exactly.
And you mentioned the one with the billboards and the more sort of routine matters mill, as you called it. The other area where this comes up is in a very highly sophisticated integration of business and law and intellectual property and et cetera. And there, I think one of the things we all have to understand is that some of that's been driven by the client, by saying, I need a place where I can go where people are talking to each other about these things, and I don't have to go one place for law and one place for investment advice, et cetera. And so again, there, I think that, obviously the unauthorized practice of law issues would be similar, but I think partly what we also need to be doing is helping lawyers, educating them to be more conversant in these other fields and to be able to work together, and law and business is a really good example, I think. Too often it's seen as the lawyers saying no and the business is saying yes and not working well together. We're also trying to put some things in place to help our students learn how to operate in a more multidisciplinary environment that I think can be helpful at that level.
Yeah, and you may know that 1 year ago, January 1st last year, in England, they started allowing 100% non-lawyer ownership of law firms. And they had already sort of been going down this road, and this was the big, 100% non-lawyer ownership. I attend a conference every year with my counterparts from around the world, so we had a chance to hear from our counterpart in England about, how's it going. The year prior, when he was talking about it, my reaction was, whoa. But then we all started talking about it. And if because there were the jokes about, well, you can go into Walmart and get your cucumbers on aisle 5 and get your estate planning on aisle 8. But then when you really step back and you think about that, what's wrong with that in some ways, right? If that's where the consumer's going and if that's, where they can get their services, I'm not saying it's that simple, but we need to think about it. Now, when we met, they were only about 8 months into this new regime, and so we'll hear more this year. But we need to watch what's going on around the world, and we can't just keep sticking our head in the sand and saying it won't happen here. I was disappointed that the American Bar Association Ethics 2020 was looking at this, and at their meeting just basically said, we're going to punt this down the road. I don't think we have time to punt anymore. We need to start taking these issues head on. So,
let's take a question over here, please.
I think the bar has to be very careful about not using regulation as kind of a economic protection. And the reality is that many of these so-called mills actually provide services at lower cost and higher quality. That's the expectation of consumers everywhere. And we haven't even begun to conceive of the directions that could go. We're essentially practicing law like it was 200 years ago. One client, one lawyer, custom documents. It's as though we're paying each lawyer to build a custom table, but IKEA builds a pretty good table for 1/10 the price, and it still holds up dishes pretty safely. And that's what we have to do. Reverend Moon married 19,000 people at a time, long before anyone here was born. We can do the same thing with dissolutions. And we have to start thinking in that way, because those people aren't being served, as you said, by the profession at all. And we've got to completely reorganize to keep up with the speed of light that the rest of the economy is changing in.
Yeah. One of the points that I think your comment suggests too is that, as Paul and I have both mentioned, we both believe technology is one of the things that we have to not fear but embrace in a positive way. And I would say a couple things about that. I mean, one is that most of us don't go to law school in order to just do routine kind of matters, right? I mean, one of the reasons we sought law out, and I know you all didn't love law school, but I bet there was some class that really, you loved, and it really, pushed your mind to think. And so one of the things to think about is that what technology can do in law is a lot of what it's done in a lot of other areas, which is take away the routine and free up space for the more creative endeavor, the more challenging one, the more complex matter. And let's face it, our world is full of complex problems that need minds that are well trained to think about. Again, one of the things that that I hear a lot from law firms is that or legal employers, I should say, is that there's still a gap between the number of people that they can hire and to really do the really complex matters that really need attention. And one of the things that I think in this change that we're going through in law school, we want to be careful of, not throwing the baby out with the bathwater, because I do think law school has been good at educating people to solve complex problems and to really think about things in an organized way, to marshal a whole lot of information in an organized way. And with no offense to my colleagues that are deans of other schools, I see this when I'm sitting around in a group of deans or chancellors of other schools and colleges. People that are law trained think about problem solving differently. It's part of what we learn. And so if we can use technology as a way to, free up the space for that kind of attention to some of our world's deepest and most challenging problems, great. Lawyers need to be at the table.
Well, and Hank, I think comment sort of reinforces everything that Kellye and I are saying. One thing I would say, some of you have seen the futures presentation I do, and I've done it with, you may know Marty Smith, who used to be a partner at Preston. And Marty's great. He's actually left the practice, well, he's sort of still involved with the profession, doing these extraordinarily innovative things with technology. And one of the things that Marty talks about is that we still act like a cottage industry, right? And so he would talk about, maybe I shouldn't have named the firm, but being at the firm and sort of walking down the halls, and it's sort of like, my no-compete clause is better than your no-compete clause, instead of sort of all coming together and saying, let's figure out the best, no-compete clause. And they've done a lot of really innovative stuff of looking at a lot of legal work is just building blocks, right? It's the commoditization that we all keep talking about. So that would be my first comment, is technology, and there's some, right here in our state, some people who are really out on the front end with this stuff. The other thing is that when the LPO rule came in, the limited practice officer rule came in, a lot of real estate lawyers thought this is the end of the real estate practice, right? But what many found was that it freed them up to do what I like to think of as the fun stuff, or if you go back to the box that none of you drew, but I asked you to draw, it's that advice and counsel at the top, right? And how do you take that process and content stuff and pass it along to other trained professionals? So that's, I think, sort of my comment about there's going to be a lot more power if we let go and start thinking sort of innovatively and using technology and other things. Oh, Rex has got another.
Rex.
So the law firms are not hiring new graduates. What advice do you have for those of us that are new graduates who are looking at job postings for lawyers for 3 to 7 years of experience?
Well, I would say I'll do a shameless plug for the State Bar's statewide moderate means program. And this is a program that we have in partnership with the 3 law schools here in the state. We pay for staffing at all the 3 law schools. They, at the law school, recruit and train students to do the client intake. So as Kellye was talking about earlier, that hands-on, skills training. So they get actual client intake experience. Our part of the deal is we recruit attorneys to agree to take these cases at a reduced fee. There's mentorship available. We provide free CLEs, so if it's in an area of law that you aren't that well trained in. And it's a great way for, I think, new lawyers in particular to get hands-on experience, hopefully start building a book of business, and then be able to go into these interviews and say, I did client intake when I was a law student, and then I took all these cases. That's one thing I would say. The other, of course, that we tell folks is get out and do pro bono with the legal aid clinics, with the neighborhood clinics, and get that hands-on experience.
Yeah, I would say, and I appreciate the question, because I worry a lot about the difficult market the new students are facing right now, and it varies a lot by city, it varies a lot by law school in terms of how that market's going, but I do think that one of the things that's true, and the question from our online participant shows, is that more and more employers are reluctant to hire entry-level persons. And I see this not only with law firms, but even judges. It's increasingly common for judges to say to me, Dean, I don't want to hire a student right out of law school. I want to hire somebody who's already been a clerk somewhere else, because then they've already been trained by them and I don't have to do that training. And so there is definitely a disinvestment by legal employers of all stripes in doing training. And so my piece of advice to the student is that in some ways what you have to do is do what Paula suggested and make yourself look more like a lateral than like an entry level, because everyone's wanting to hire laterals and with experience, and be very broad in scope and geography about where you want to work and get that first level of experience. One of the difficulties I know that some cities will see is that if all the students that graduate from a particular law school want to stay right there, that's going to be very hard to do. Whereas if you're willing to go, to another large city for a while to get some experience, it's probably easier there to enter that market, because legal employers also like to hire from a diversity of law schools rather than hiring everybody, from the same school. So I would say, and work your networks and really be broad in both scope of work you're interested in, and be very broad in geography for that first place to get started, and then you'll be more in the lateral market from there out in terms of the next move.
Question here.
Good evening. My name is Alex Bizou. I'm a young attorney. I was licensed at the end of 2011, and thanks God my loan is very moderate. But I guess I'm in the category that we're addressing now. And I always wanted to be independent, so I'm a solo attorney. I guess most statistical resources say that majority of lawyers in America are solos or in a small firm practice, like 2 or 3 lawyers. Maybe they're wrong, but that's what they say. And what I experienced in the first year of my solo practice is that I was not able to get a malpractice insurance, and the solo attorney that is in business in the first year, his first task is to attract clients. The referral services in county bars, they don't accept you unless you have a malpractice insurance. No company gives a quote when you're first year. Thank God I got a first affordable quote just a few days ago after I hit this 1 year of practice. So hopefully I will get into this referral services, and moderate means it also requires a malpractice insurance. From my perspective, I risk my license anyway. Why? I understand it's extra safety measure, and my another question is there is this website now, avo.com. And it bombards lawyers with emails. It serves through bar websites and opens an account for every lawyer and starts rating them without even them participating. And after that, they engage lawyers in this filling out of their profile. And it's now becoming very popular, this website. Does Washington Bar Association communicate in any way or tries to influence the ranking system of that website? Because there is a lot of discussion now online on Google+. Many lawyers nationwide talk about these rankings, that the system is unfair, and this is the number one website that people click on when they search for a lawyer and they look lawyers' credentials. And lawyers like me, they have to cope and survive in this environment. Thank you.
So let me take your first question about malpractice insurance. And actually, on the statewide moderate means panel, it's true you have to have malpractice insurance to be on the panel, but we're in an arrangement with the bar sponsors malpractice insurance, and they've agreed to offer malpractice to the moderate means folks at a reduced price. So I want to say it's $200, but that may not be right. So there's more incentive to get involved with the moderate means program. Interestingly, the Board of Governors meets with the Supreme Court once a year in January, and we meet for about 4 hours, and we go through a whole bunch of issues. And one of the issues that was on the agenda, I'll say that was asked to be put on there by the court, was mandatory malpractice insurance. As you know, Oregon is the only state in the United States that requires malpractice insurance. The bar had a huge task force last year that came forward with recommendations to the admission to practice rules, and included in that recommendation was we should get a task force going to look at mandatory malpractice insurance. The Board of Governors decided that there's a lot going on right now. This isn't the time to take up the issue, but we did have a long conversation with the Supreme Court about it last week. And so we're actually going to be sitting down with our law office management assistants, program managers, and some other folks on staff to start looking at what are our options. Can we help create pools? Because it's definitely an issue. We hear about it not just from new lawyers, we hear about it from actually established lawyers who reach a certain point in their career, and then it becomes exorbitantly expensive, and which is sort of counterintuitive. So this is an issue that we're definitely looking at. AVO, we're not involved with AVO. When they first started, they came and asked for our data, and we said no. But we know that there's web crawlers out there every night mining the information off of our website that we can't control. But it's an interesting question. But we haven't had much conversation with them. I'm not sure how we would influence how they're rating people, but maybe it's something we should talk to them about. Interesting question. Thanks.
Mr. Gates.
Two or 3 years ago, it seems to me there was significant publicity about change that was occurring in the law business, and particularly in large law firms and large clients. And the basis upon which lawyers were being paid was being changed rather dramatically, and what I mean is lower. And then now that I'm not seeing anything about that, I'm curious if you, either the two of you or both of you, have any insight about whether that phenomenon is one that went on to establish a general new level, or if it was just a little outcropping here and there and hasn't become part of the economy of the law practice. If you have anything that you know about that, I'd be very interested in what it is.
So the ABA Journal's done a couple of articles, and so I can get those and pass them along. I wouldn't say that it's had a huge revolutionary impact. I think maybe where we've seen it is with entering associates. There was sort of the entering associates making $160,000 a year and things like that. But going back to sort of my opening remarks about the end of the billable hour and sort of the value-based billing, I think a lot of what's going to drive these things is corporate clients and sort of a shift in the market in general. You've heard about the legal process outsourcing, which is shipping off legal services to India is the big one, but the Philippines and other places. And if you haven't gone out and looked at their websites, I really encourage you to do it. It's very interesting to go out and look at what these outsourcers are doing, because it's any kind of work you can imagine. It's anything. And that industry continues to grow. There was speculation that the recession would sort of tamp it down, but it hasn't. It continues to grow. So I think, and I think Kellye mentioned this earlier, there's a bunch of things at play that are impacting the economics of the practice and I think what people get paid. I don't think we're seeing huge changes right away, but the ABA has definitely been doing some surveying and sort of what are top partners being paid and is that coming down? So I'm happy to pass that along.
Yeah, I would just add that and the information I have on this is really anecdotal rather than anything systematic, because it's more when I'm out talking to partners, I hear, I ask questions like that and just want to know what's going on. And from what I understand, there was kind of this initial wave of attention on it as if it was all going to just change dramatically, and a lot of attention on it. And then there was sort of a backing off because it's hard to figure out, flat fee for. The more complex the thing is, the harder it is to figure it out. And so some of the talk about it then kind of pulled back. And so I think it's very segmented. I think there's some matters now where it was easier to figure out what that might be, and some areas of practice where it's more common. I think others sort of started down that road and now have come back the other way. And then the other thing too with the outsourcing is I've recently heard a lot of discussion too where people had tried that, they weren't quite getting what they wanted out of it, and now that's been pulled back, and in some areas you're seeing much less of it again. But if you look at the information on profits per partner, it's pretty high. It's going soaring along. And so I think that there's just a lot of innovation happening out there too, Bill. When the advertisement went out about this program, I heard from a lot of my former students, and which is always such a joy. But, and some of them said to me, this is what I'm doing now, and it might fit in with, you might be interested in it given the subject of your discussion. And I'll just give one example. One student is now has formed what is a virtual law firm. She's in Albuquerque. Everyone else is in everywhere from Japan to Italy and other parts of the United States and other countries around the world. They do all their work on flat fee. It's designed for startup businesses. It's very entrepreneurial focused, and they're sort of general counsels on call for a lot of these businesses. There's also I had a student write to me and say, I've never been happier practicing law. I do all my client work flat fee. I do a lot of fairly basic and routine matters, but I love it because I'm taking care of real people out there who have everyday problems, and I'm not going to be a millionaire, but I have a good life. So I think there's just all kinds of things, happening that people are making, different kind of choices on. But I do think, again, to technology, I think there's going to be a lot of change in terms of the way firms think of themselves and the way legal services are delivered. Things that are a lot more possible now than they've been. So
I think it's important to drive home a point you made earlier, though, which is the vast majority of lawyers are not working in the big firms, and they're not working in public interest. And the median income for lawyers is $62,000. And I don't think that needle has changed much. So, a lot of people getting rich.
Rex?
The WSBA Rule 6 law program is where one studies to be a lawyer and sit for the bar studies to be a lawyer for 4 years under an experienced attorney and then sits for the bar. A lot of people are unaware that this WSBA program exists. Does WSBA leadership see this program continuing as an available alternative option to law schools?
Great. So, right, if you're not familiar, you can still read for the law in Washington State. We're one of the few states where you can still do that. It's a fabulous program. And so the State Bar is very committed to it, and the Supreme Court has made very clear to us that they're very committed to it, and it's their rule. So that's great. I will say we have seen an increase in folks applying and entering into the law clerk program, and I think part of that is actually related to law school tuitions. So it's a great program. We're actually been having some conversations with one of the local law schools and one of the bar prep courses about how can we make the actual curricular side of it stronger. We're great at the regulation, but we're not legal educators. So, but it's a great program. I think it provides access. So.
Yeah, I've got like 7 in the queue. What role do you see alternative dispute resolution methods, such as mediation, playing in the changing nature of our profession?
I'll start on that one. I think it's huge, and I think it's one of the areas that law schools have been a little slow to catch up on. There's much of the first year curriculum is still taught through the lens of appellate cases. And so it's something that we really, all of us in legal education, have been trying to move the needle on over the years. I always say that, in running a law school, there's sort of clear divisions of authority between deans and faculty. And one of the things the faculty is clearly in charge of is the curriculum. And so as a result, change happens more slowly because you have a big group of people needing to figure out what they want to do to change a curriculum. And so right now what we've done is more add-on courses instead of changing more fundamentally what's taught in the basics. But I think, as we all know, those are areas that lawyers deal with all the time. I hear stories all the time of lawyers that needed to go do pro bono work in order to do trial work or anything, and so that recognition that what you're actually going to be doing out in the field is less about trials and appellate litigation for some people than the dispute resolution.
I would completely agree with that, and I will preface my next comments by saying I'm a huge supporter of ADR, and I think it's great. My concern is that as we starve the courts, and it becomes more and more difficult to get into the courthouse. We know even in our state that sometimes it takes 2 years to get a civil case heard, that we increasingly privatize our judiciary, and that concerns me. So I think there's a balance of mediation and our alternative dispute resolution is huge, great for all the reasons that the dean outlined, but we also need to be taking care of our judiciary and people getting access to the courts.
So some law schools and state bars are looking at revising what the third year of law school looks like, or possibly eliminating the year altogether. Assuming the ABA would allow such changes without threatening loss of accreditation, what are your thoughts on this as a partial solution to the student debt issue?
So let me start by saying that, there's always been this saying about the first year they scare you to death, the second year they work you to death, and the third year they bore you to death, right? And like a lot of sayings, there's always a little bit of an element of something there that generated it. I think that used to be so much more true than it's been for years in law schools. And again, I think it's because of the answer to your question, which is that so many of the skills courses are now available for students to take. And so that third year turns out to be one where students can start to specialize or just get a lot more of skills education. And it really, I think, is a meaningful part of legal education in a way that maybe we could have questioned it at an earlier time. I think that idea, though, of making law school 2 years is one of those kind of ideas that it just sounds like such a good idea that everyone's really jumping on that. And so it wouldn't surprise me to see some changes made in that regard where students could opt to have a 2-year degree or a 3-year JD. And then we would sort of let the student decide and the market decide about who was going to be hired, et cetera. It wouldn't surprise me at all to see that start to take place pretty quickly, because this is one of the ideas that I think is really starting to get some traction, in part because it's sort of simple. Okay, we have a big problem on our hands, lob off the third year of law school. I don't know that I think it's that smart a solution to. I think the things we're all talking about are much more complex, and but again, I would not be surprised to see that happen.
The ABA task force is looking at the future of legal education, just put out its sort of preliminary thinking, and they're going to have a public hearing next Saturday in Dallas. So I encourage you to go to the task force's website because they've put out some of our preliminary thinking on this. And one of the things that we did talk about is this concept that law schools are not one size fits all. And if you even think about the classmates you had, we were all sort of on different paths doing different things. So how do we work with the academy and work with the ABA to sort of figure out what we're trying to produce?
I might add one quick point about that too, is one of the things that worries me about it is, so as Paula said, the idea could be, okay, don't make all law schools be the same. You could have a 2-year law school that turns out practitioners in family law. You could have a law school that is more about, interdisciplinary research or, so let them pick their mission, let them pick their specialty, and then student, you pick by what you want. What worries me about that is every study that's ever done shows that largely we don't know what we want to do when we come into law school. We don't have, like medicine, we don't have a curriculum you have to take before you get admitted. I always have students fill out as they come into law school, what do you think you want to study? And then at the end, what do you think you want to study? They're usually very opposite. And so there's a lot of the time that we find our passion in law school, or we find it even in the first job or something like that. And so I worry a little bit about a program that makes people declare what they're going to be so early, because I think that you all know many stories, right, where you went to law school thinking maybe you're going to practice criminal law. And then, you took a business organizations class, loved it, and you've done corporate transactions or what have you, and had a really enjoyable life, and your passion matched up with your work, and it was, good. So that's some of what I worry about with that. The other thing I worry about is, we've just heard a lot of things here today where everybody wants law schools to do more, right? We want lawyers to be more ethical. We want them to have all these other skills. We want them to have practice skills as well as the thinking like a lawyer skill. That's totally opposite of thinking we can shorten the time, right? It's very hard to do more in less time. So I think we've got to resolve some of what we're asking, for in that regard.
Well, and I won't get on my soapbox about this one, but when I was assistant dean at the UW Law School, and I still believe this, that I think law schools should be interviewing. I think, if you think of classmates you came out with and they got 2 years into it and they just said, I don't like it. I would be like, why did you do it? Well, it seemed like a good thing to do. Making people sit down, and talk to a panel of 3 people, like in medicine, and say why you want to do it. So I know that's a dream.
But it's more common. I mean, today, more and more students have worked before they come to law school. And that's also something that enhances their resume as then they go out to work in law. Our average age, I think, is around 27. And, I think that, that's, and some law schools are doing interviews, and we certainly look at the full range of application and interview most students.
Well, and I just want to really reinforce something that Kellye said, which is as we sort of rethink legal education, you'll hear people say, oh yeah, think like a lawyer. You know what? You have to learn to think like a lawyer.
Somewhere.
And as somebody who did a master's degree at the same time that I was doing my JD, it's really different in how you learn to think as a lawyer. And so even in these ABA task force discussions, there's several of us who keep saying, we've got to rethink it, but don't forget there is something you have to learn in law school, and that is to think like a lawyer. So, we can't throw the baby out with the bathwater, I suppose.
Yeah.
Way back here.
Hi, I had a question for both of you. What do you think has caused the current crisis? And I guess, as a side note, who should be responsible for cleaning it up? Besides you guys.
We're going to do it tonight in the next 15 minutes.
So let me say that, again, I think that what's interesting about the fact that the discussion about law, the legal profession, legal education has bubbled up so robustly. And it's been in the New York Times, and there's all kinds of debates and articles there. That in some ways ought to show us that we're kind of interesting to everyone, right? Because think about all the other fields in the world where there's probably more of a problem of where are those graduates going, right? Like I heard today a statistic in our President's Council at UW that there were 28,000 applications for graduate school at UW for 3,500 spots. That's not including the professional schools. That's just through the graduate school itself for, the masters and PhDs of whatever. And so what I would say about this is that I think it proves, one, law continues to be of total public interest to everyone. It sort of rises up as the thing to talk about. And so in many ways, that's created its own storm of interest and push. Again, I don't bemoan that because I think that it's been a nice catalyst for change and maybe pushing forward some questions that we needed to be asking anyway due to some of the factors we've been, talking about tonight. But I take a huge amount of responsibility. I think legal education has to take huge responsibility for this, as do all members of our profession. We are a self-regulating profession. And I think, when you think about the attacks on, this idea of should there be fewer lawyers, well, remember the old saying from Shakespeare, right? First kill all the lawyers. That wasn't because they didn't like lawyers, it was because you need to get them out of the way so you can do bad things. We're the guardians of our Constitution and of liberty and also, as I said, I believe we're in many ways, the people who can most solve the problems that our world needs us to be addressing. So I think we all have a responsibility to think about how we're educating the new lawyers, how we're mentoring them, how our firms are serving the public, how they're not, and what we can each and all do about it.
And I'll just say again, I think it's an opportunity. I don't think it's a crisis, or don't waste a good crisis, right? I think it's an opportunity, and I think all the 5 factors that I lined out, I mean, a lot of this is stuff we didn't have, we don't have control over. The changing demographic of the lawyers, the technology, the haves and the have-nots getting further apart. But we, as a profession, have to own the solutions. And I think that what we have to do is we have to innovate. And so I'll give you a sort of sneak preview of my column in February where I'm going to talk about this, but I think there's 3 things that we need to do in innovating. The first is we have to rethink the judiciary. We are working in a judicial system that was created hundreds of years ago and trying to make it work in a totally changed global context. In this day and age that you have to go to in some counties, a courthouse 8 times to get your divorce, doesn't make sense when you can, do your license online. We aren't sort of rethinking things. And the courts are in a funding crisis. But what we do is we keep asking the legislature to fund a system that has come to the end of its useful life. And what we need to do is rethink the judiciary, rethink how we're going to serve the public in this changing environment, and then go down to the legislature and say, help us fund this. Now, we live in a state where our judiciary is doing some really innovative stuff in different parts of the state. And we have a Chief Justice who is absolutely committed to bringing the judicial branch together to rethink everything. But we've all got to be involved. It's not just the judges, it has to be the profession. So the first thing is we've got to rethink the judiciary and how we deliver those services. The second thing is we've made the system too complex, and we as lawyers have to own that. I'm a lawyer, and there's stuff that I can't figure out, and it's just too complex. Now, I'm not going to say there aren't reasons for some of that complexity, but we've got to start simplifying it. We've got to start looking at what we're doing and figuring out where there's redundancies. And if you talk to some of the lawyer legislators, they sort of say, there's a state statute that says every year the Supreme Court is supposed to come forward and say, here's the duplicate statutes, here's some, and it's not happening for whatever reason. That doesn't matter. We've got to own it as the lawyers. We've got to own that the system is too complex. I think the third thing is clients. There's a lot of pro se clients, and in the recession, we've seen pro se clients go up. But the reality is that if we give some of these pro ses the tools, they can do it. Many of these people are highly educated and they're smart. And if we give them the tools, they can do it. So we need to start innovating. And I'll go back to what I said earlier. We're never going to have enough lawyers to serve everybody. It's just not reality. And so we have to start thinking about other ways to make our services available, or we're going to lose the whole kit and caboodle, which is what's happening in these other countries that I cited. And England is not a slacker democracy. It's one of the biggest financial base, so we really have to look at what's going on in other places and not keep kidding ourselves that we can't not make changes. So I think we have to innovate. And the thing for me is we're problem solvers. That's what lawyers are. That's what we got trained to do, and that's what we love to do. So let's do it. But I think the profession absolutely has to own it, working with the academy. Now you don't have to read the column, but there's other good articles in the February issue of Northwest Lawyer.
Thanks.
Some psychiatrists are now providing online Skype therapy sessions with their clients. Please discuss the application in the law firm context.
We're actually doing some of that. We call it long-distance lawyering. And we had a pilot going in Grant County and for various reasons had to stop. And I think we've been in conversations with Walla Walla County, but I'm not sure. And the idea is that, of course, most of the lawyers live on this side of the state. So how do we get lawyers that want to do pro bono and other sort of services out to other areas? So we work with the judiciary, but absolutely, that just goes back to the whole technology thing. How can we use technology? So we're starting to step into that and see what we can figure out.
Yeah. I think things like that are exciting because so many times what a person needs is just some some basic guidance, and it can be, that's a way to just expand access so much. I get so many calls at the University of Washington as sort of a place of last resort where people have they'll call me or they'll email me and say, I'm desperate. I've talked to, I've called 9 numbers. None of the lines really pick up. There's no person, this happened to me and I'm trying to find, just a place. And I try and make sure I answer all those kinds of calls and just give somebody a foothold of a place to go, because, so any way that technology can help us expand that kind of a service for the public, I think is going to be something that is really good for our profession, because then people respect us. They feel that we're responsive to their need. And obviously, when the legal profession depends for its legitimacy on the respect of the public, that's just a vital component of what we do.
I think Ken has a...
Well, it's really great to listen to you. These are incredibly huge, complex issues. Certainly the triple LT rule is not going to solve the problems that you're talking about anymore, or any one of the changes. I want to say it's wonderful to have people like you that are thinking about the big issues and trying to work through them. I also want to say, though, going back to the triple LT and other things like that, I think that it's an interesting, Paula, when you talk about the median income at 62, that means that half the lawyers are making less than that. And I think some of the pushback we get in the bar is that they see their income down there and they see the possibility of losing even that. And as we bring in people who are going to undersell them, and there's a great deal of concern that not just people who really can't afford legal services, but people sort of in the middle of the income group who really don't feel like they're able to afford a lawyer, although they may well be, are going to see this as a great opportunity and pull the base out. And my real concern about that is, as you say, in a lot of ways, there is and will be a shortage of lawyers who can really help people who need lawyers. And I just hope that as we grapple with these difficult issues, we don't wind up making that shortage worse by driving out people who make a very moderate income as lawyers and help a lot of people.
Couldn't agree more.
I think too, Ken, we've got to find a better name than triple LT.
We tried.
Maybe we should have a contest for that and talk a little innovation.
Better than a bill.
That's right.
Well, let me ask a question, something that's near and dear to my heart. I know there are a number of firms in town that are now dealing with the glut of baby boomers that are about to retire from the practice of law. Can you give any insight as to how that's going to affect the legal profession, how it's going to affect the young lawyers looking for work, and just exactly how the law firms are dealing with that issue?
Let me start with a few points about that, and it's a really good question and topic for us to talk about, because there are a number of issues wrapped up in it. I mean, one that I hear a lot is people that are transitioning out of practice feeling like they don't have anyone to hand off to. And so it seems to me that, again, we have this mismatch, right? We have people who are looking for new lawyers to hand off to, but there's no match there made. And so that's something that I feel like, I know, and Paula can address this, that we're trying to work on.
We just launched it yesterday.
We just launched this program, so she'll get to hit that ball right out of the park in a moment. But the other thing that I find too is that, many persons who decide to, step down or retire from full-time practice, there's so much that is needed that they can contribute. And I know that I've been incredibly lucky when I was at Seattle University and also now, in having persons who have made that decision to come into the law school and be mentors to our students and, frankly, mentors to our faculty, because many faculty have been out of practice for quite a while. And so to have that infusion is really healthy for the faculty in the law school and for the students, and I think for the person as well, in terms of just enjoying that kind of work. So I hope we can continue to think about ways to leverage that incredible talent pool, that's an experience pool that's there at a time when we really are needing mentoring, and the infusion of the practice world into the education world.
Well, that's huge. The sort of the brain drain, the experience drain, and the leadership drain. There was a ABA president several years ago who her whole presidency was around the second season of service, which is how do you capture these attorneys that are transitioning out, but keep them engaged, whether it's pro bono, whether it's mentoring, whatever it is. So that's certainly something we're working on a lot, and I know a lot of the county bars are doing a lot on this. The program that we just launched this week is called the Practice Transition Opportunities, and this is literally a matching system where lawyers who are looking to transition out and sell their practice can put that up on the website, and then new lawyers or even mid-career transitioning lawyers can go and look at these, practices that are for sale, and hopefully there's sort of a matching or a marriage there. One of the things that we hope will come out of it is that it's not just a sale of the practice, but an actual overlap, like Kellye was talking about, where there's some mentoring and sort of getting to know this lawyer's clients, and it's sort of a smooth transition. But I encourage you to go out to the bar's website. We haven't sort of promote it yet to the membership. That'll be coming because it just went live a couple days ago. But there's one link that says, ending your career, and one link that says starting your career, and it's got more, other resources, not just this practice transition opportunities, but it's something that we were working with the 3 law schools on, an idea by our president last year, Steve Crossland. So we're pretty excited.
Yeah, it's a great deal.
Well, thank you very much. I think we really don't have time for more questions. It's been a great discussion, and Paula will look forward to your February issue of the Bar News. But would you like to have some closing remarks? Kellye,
I would just quickly say that I really appreciate you all being here, both those of you who are in the room and those of you who are online. And I, again, feel very heartened by where we're all heading and the kind of questions we're asking, and would just say that, as Washington's public law school, we are really eager to be a partner with all of you and trying to move our profession forward. And so if there's any way we can further engage with this topic or be of help, we're eager to do so. So thank you very much for being here tonight.
Great. And I would, I'll be fast. I would just say the title of my column that was in January, which is Seize the Moment. We're really excited to live in a state where we work closely with the 3 law schools and the Bar Association, where not every state is like that. We work very closely together. We work very closely with our Supreme Court. So I really invite all of you to get involved. Like I said, we're lawyers. We love this stuff. This is a big opportunity, and we can figure it out working together. So I think it's exciting, and I just really encourage you to get involved and stay in the dialogue.
Thank you very much.